The best test of the independence of the Supreme Court of India lies in the nature of its decisions and in its willingness to exercise fearlessly its powers of judicial review of both legislation and executive action. This is a quote I read somewhere. In the last 10 years of Prime Minister Modi's government, has the Supreme Court lived up to this expectation? Allegations of institutional capture by Prime Minister Modi's government have been one of the highlights of the last 10 years. Why was this the situation? And can we expect things to change? Are much needed judicial reforms on the right track? These are some questions I will try to answer in this third episode of the Justice Brief. Before I begin, remember that judicial reforms are bottom on the list of priority agendas for political parties. This is despite the important position the judiciary occupies in our everyday lives. It is said that there are only two kinds of Indians, one who is stuck in the courts and the other stuck running away from the courts. The situation is worrisome and Prime Minister Modi's government does not seem to have a great plan to curb the many problems that ail the judiciary. I will tell you why. But understand that as per an estimate from 2016, the cost of the delays in the judicial system could be anywhere around 0.5 to 2% of the GDP. That's a huge number. The delays also contribute to lower ease of doing business in India. Recently, lawyers have been crying about how arbitration in India must never be an option, simply because there is no consistency. Other concerns like shifting of politically sensitive cases to select judges using the master of roster powers, inconsistency in applying and interpreting laws, and the larger issue of opaque appointment and transfers of judges continue to loom over our heads. Before understanding what situation we are in today, and what the situation could be, it is important you understand the judicial system today, especially the Supreme Court. Ever since India gained independence, its judiciary, especially the Supreme Court, has been in the center of our polity. It is arguably the most powerful top court in the world. If you tame the Supreme Court, it could serve as a potent weapon for a regime. But why is it the most powerful top court? Firstly, the Indian Constitution under Article 136 allows the Supreme Court to entertain any case under the sky, if it wants to. This is called the special leave to appeal. The system today is that cases which are decided by the High Courts can be challenged in the Supreme Court if the High Court certifies that this case is a fit one for challenge. If the High Court thinks the Supreme Court need not be burdened since the case does not involve important questions of law, it can deny this certificate. So you would think the denial of certificate would be the end of it, right? But Article 136 of the Constitution still allows you to appeal to the Supreme Court and ask for its permission to bring the case there. This is called asking for the special leave. If the Supreme Court bench agrees, it can admit the special leave petition and later hear the challenge. But remember, this is an extraordinary power of the court. Back in 2002, the Supreme Court had said that it should exercise its powers under special leave to appeal only in exceptional cases involving a substantial question of law or a manifest injustice. So only if extraordinary reasons exist, the Supreme Court should admit such a petition. Today, such petitions form 99% of the pending cases before the Supreme Court. The extraordinary has become ordinary in today's India. The second reason why India's Supreme Court is the most powerful in the world is because of Article 142 in the Indian Constitution. It says that the Supreme Court has the powers to do complete justice in any case that it hears. This means that if there is no law or guidelines, etc., the court can pass any kind of order or judgment it feels would be necessary to do complete justice. Take for example the Ayodhya judgment. The court used its Article 142 powers to allot 5 acres of alternate land to the Muslim side in order to do complete justice, even though there was no law supporting this. These are again extraordinary powers. Author Anuj Bhuvania, in his 2017 book Quoting the People, pulled out certain interesting observations made by the members of the Constituent Assembly during the debates that took place while the Constitution was being created, that was between 1947 to 1950. One of the members had said that these powers of the Supreme Court to do as they like for complete justice is similar to the divine right of the kings and queens, meaning that the Supreme Court judges could invoke these powers to do as they wish, like how kings and queens could order whatever they thought was okay. Another member even called the Supreme Court a potential Frankenstein monster, something that cannot be controlled or that could bring ruin for the creator themselves. You may be thinking why the constitution makers gave the Supreme Court such wide powers. There's some hint of this in George Gadbois' book, Supreme Court of India, The Beginnings. You must read it. This reputed author argues that the courts of the British Raj enjoyed the great confidence of the Indian people. The courts were seen as credible, impartial, and holding themselves to great standards, much like how it is in the UK today. So naturally, Indian leaders expected that the courts in independent India, they would too continue this tradition of upholding highest standards of independence, integrity, and impartiality. So they did not see a reason to restrict its powers. Skip to 75 years later, this is now debatable. There are other instances where India's Supreme Court gave itself a lot more power than what the constitution makers did. Like in the 1978 case of Menka Gandhi, the Supreme Court held that any procedure which affected a person's life or liberty must be just, fair and reasonable, not fanciful, oppressive or arbitrary. Ever since, courts have interpreted to judge whether a law was a good or a bad one. If it's a bad one, it can strike it down. The power of judicial review was thus expanded. The Basic Structure Doctrine from 1973 is also a case where the Supreme Court gave itself the power to strike down amendments to the Constitution if they violate the basic structure of constitutional principles and values of the Indian Constitution. Today, members of Prime Minister Modi's government are up in arms against this judgment. Like Vice President Jagdeep Dhankar, although not officially a BJP member now, but certainly in spirit, who has said the judgment was a bad precedent and that if any authority questions Parliament's power to amend the Constitution, it would be difficult to say we are a democratic nation. Anyway, by now you have understood why the Indian Supreme Court is perhaps the most powerful top court amongst other countries. So much power with absolutely no accountability. The courts are expected to self-regulate their procedures. But the situation has come to such a dire state that it is time radical reforms are initiated. There are over 5 crore cases pending in our courts and there is simply no action plan. There is no consistency in the manner in which our courts interpret the same law. Bail is granted to some immediately and to some after years of delay, despite a clearly weak case and an even weaker evidence. Judges are appointing judges without any transparency or accountability. Questions of merit and nepotism arise as a result. Today, there is a lack of judges with mettle, too easy to bend. The same judges are also refusing to publicly declare their assets and liabilities every year, despite all officers having to do so. There are grave problems with the current systems like Master of Roster and the manner in which the registries of the courts function. Allegations of corruption, bribery are plenty. Extraneous pressures from the government of the day are talked about in power corridors. At the same time, there is simply no mechanism to fix accountability. So do we see reforms coming to life? Not really. I spoke with a number of lawyers in the legal profession and many said that things are not going to change. You may think of them as pessimists, but their statements have deep roots in reality and are not to be taken lightly. When I spoke with senior advocate Sanjay Hegde and asked him if the return of a coalition government would mean a stronger judiciary, he said, hopefully the Supreme Court will be equally solicitous of the liberty of all citizens, whether they are called Arnab Goswami or not. One would agree, and even former judges have now agreed, that the judiciary is stronger when the government is weak. That means coalition government. When I asked Hegde if the problem today is about judges who are purely partisan in nature, driven by ideological leanings, unable to keep aside their personal biases while judging important cases, he said they may have an ideology, might guide them in matters of temple, mosque, etc., but basic defense of human liberty and dignity is what I am currently looking for. Right now, policemen have the right to lock you away indefinitely without accountability to the courts and the constitution. There are certain others who said they foresee no change in the way the judiciary conducts itself in Modi's third term. I think there are two explanations for the problems here. First would be when the current systems work well for both sides, and two would be reasons that are historical in nature. In the first one, much of the serious reforms I told you about would essentially require the judiciary to let go of certain opaque powers that it enjoys today. Like, say, reforms in the Master of Roster system or the collegium powers of the senior most judges of the court. This is really difficult to let go because you're accustomed to a certain way of things. The government of the day would also be happy to not reform, say, the Master of Roster powers, because it is perhaps certainly working for them in the present form. Certain cases that are shifted to a particular judge with a particular kind of bias are perhaps benefiting the government of the day. The Chief Justice, while using these powers, also does not owe an explanation for his actions, so it is a free pass. Now just imagine declaring in writing why a particular case is not being listed or why it is suddenly shifted to another bench. That might become problematic even for the government, which might stand to benefit from a particular case being shifted to a particular judge. Look at the collegium system. If the collegium puts out a rule saying that there will be great transparency in the decision-making process, records, IB inputs, reasonings, etc. will all be put in public domain, it will lead to problems for the establishment. What about all the closed-door negotiations and recommendations? So the current system is sort of working for each other already. It's a win-win situation for both sides. Of course, the losers are regular litigants like you and I who might have to put up with an unworthy judge in a case. There are some within the system who are also at a disadvantage, like a fair judge who is sidelined from important cases. One possible way to change would be when the judiciary exercises its powers in a way that may be perceived as independent or go against the government's interest. Only then would the government have problems. See how Pakistan's parliament brought in a law to reform the Master of Roster powers of the Chief Justice of Pakistan. It was very similar to what we have here. In April 2023, the law diluted his powers and constituted a collegium that included the next two senior-most judges with him to decide allocation of cases. This was because the then Chief Justice of Pakistan, Umar Ata Bandial, was alleged to have been favoring Imran Khan and allocating cases to specific judges. The second reason is more historical or traditional. When it comes to matters of liberty, the Supreme Court has been rather conservative in its approach ever since it was created in 1950. Noted criminal lawyer Abhinav Sekhri, while critiquing the draconian PMLA validity judgment of the Supreme Court in 2022, wrote, which is why, before getting into analysis of this judgment, it is important that we dispel the thought that the Supreme Court has gone out of its way in this judgment to strike a blow for fundamental freedoms. It was quite the opposite. The Supreme Court merely had to remain on the path that it had charted for more than half a century to arrive at the verdict in Vijay Madan Lal Chaudhary, and it happily chose this conservative path rather than adopt a radical departure from the status quo. In other words, the Supreme Court upholding the draconian PMLA and its provisions is not something very different from what it usually does. It has always remained on a conservative path and enabled legislations that have dealt a serious blow to liberty. The Supreme Court has always been very meek, very timid when it comes to matters of personal liberty, and especially when a person's liberty is in tension with concerns of national security. See the ADM Jabalpur case during the emergency. The Supreme Court upheld the law MISA, Maintenance of Internal Security Act, which was greatly misused by Mrs. Gandhi's government to detain individuals without trial. The Supreme Court controversially ruled that during the emergency, the right to personal liberty could be suspended. Then come 18 years later, in 1994, the Supreme Court upheld TADA, Terrorist and Disruptive Activities Prevention Act. This law was made to combat terrorism and allowed for extended detention without trial and allowed statements given to police to be admitted as evidence in court. So of course, a law meant to be misused was misused. Numerous cases of torture by police came to light, yet the Supreme Court took a hands-off approach and upheld the constitutionality of this terrible law, saying it was in the interest of the state to combat terrorism. 1 year after this judgment, it was people's pressure due to which the government decided to discontinue the law. Then 10 years later, in 2004, the Supreme Court upheld the constitutionality of POTA, Prevention of Terrorism Act, which was brought in after the 2001 Parliament attack and allowed up to 180 days of detention. Again, similar to TADA, lot of misuse and cases of torture. The same year as the Supreme Court's judgment, the government discontinued the law. We then enter Prime Minister Modi's era of draconian laws. In 2019, the Supreme Court upheld the bail provisions of the UAPA, Unlawful Activities Prevention Act. Not the entire law, but the bail provision. Not only did the Supreme Court uphold this bail provision, but it also restricted the courts from applying their independent mind. Then come 3 years later, in 2022, the Supreme Court upheld the PMLA, the same law that is being used, allegedly misused, by Modi's government to jail political opposition leaders using the ED. More on these two laws in the other two episodes of the Justice Brief. In Prime Minister Modi's first two terms, the Supreme Court has continued its track record of upholding draconian laws, limiting any little safeguard against its misuse, and once in a while granting bail to those who have unjustly suffered years of jail time without the state having any evidence against them. The court has perhaps granted bail at the end, but only after the state's objective was fulfilled of letting the individual rot in jail for some time to teach them a lesson and also to send across a chilling message. What about the high courts, you may wonder? It's very difficult to generalize, but since in India every system is so top heavy, what the Supreme Court does is what is also picked up as signals by the high courts. So are things going to change? The answer may be no. There may not be a major confrontation between the government and the judiciary, which may lead to Parliament changing the judiciary's practice and procedures. In matters of liberty, there will be an occasional relief here and there, but a radical difference in the court's way of working and dispensing justice is not expected. Because as I told you, one, the current system sort of benefits both sides, and two, because the traditional way of working of the Supreme Court. To the credit of Prime Minister Modi's government, an attempt was made to bring in one much required reform through the National Judicial Appointments Commission. This law, passed unanimously by the Parliament in 2014, envisaged a commission consisting of both judges, ministers and jurists that would be responsible for the appointment and transfer of judges. But this reform was struck down by the Supreme Court in 2015 for being unconstitutional, as it affected the independence of the judiciary. Since then, the government has not attempted to revive the law. Another attempt by Prime Minister Modi's government has been about assets declaration by judges. Last year, on the recommendation of a parliamentary committee that asked the government to bring a law or make rules for mandatory disclosure of assets of judges, the Ministry of Law and Justice has initiated discussion with the Supreme Court on the matter. An important intervention thanks to the parliamentary committee headed by late BJP MP Sushil Kumar Modi. Whether it actually comes to life is up to Prime Minister Modi's government. Major reforms, however, are not in sight. If you read the election manifesto of the two biggest parties, you will find that BJP's manifesto has no big-ticket reforms promised for the judiciary. They only promise to expedite the resolution of old cases, digitization of courts, and to promote arbitration and mediation. No details about how they would go about all this were given. The Congress, on the other hand, promised to create a NJAC sort of body for appointments and transfer of judges, divide the Supreme Court into two divisions, one that would only hear constitutional cases or cases of national importance and would be composed of 7 senior-most judges, and the other, a court of appeal of 3 judge benches to only hear appeals. It also promised to create a Judicial Complaints Commission of retiree judges to investigate complaints of misconduct against judges of the higher judiciary. Greater representation of marginalized groups and modernization of the infrastructure were also key promises. One of the most important ones, however, was the promise to bring a law on bail, maybe similar to the Bail Act in England. Congress promised that such a law will incorporate the principle bail is the rule, jail is the exception. This would have been a major reform and ensure to an extent that bail is not denied in deserving cases. But no such promises are found in the BJP's manifesto. In 2022, the Supreme Court had recommended the central government to enact such a bail act to streamline the grant of bail. In February 2024, the Supreme Court again asked if the government was pondering over this recommendation. But seeing how the three new criminal laws have some very problematic and draconian provisions, most with a view of retribution, not correction, it is perhaps unlikely the present government would bring in a liberal bail law. While we wait for the government to enact reforms, it is now on the parliamentarians to raise issues concerning the judiciary. The system is crippled and reforms are badly required. Through debates, discussions, and questions and answers, parliamentarians could highlight such issues and bring it to the government's attention. Responsibility also falls on the citizens to talk about these issues, highlight them, and when need be, flag it to the parliamentarians. And that's all on this episode of the Justice Brief. If you like this, like the video and share it. I will see you all very soon. Until then, stay curious, stay informed, and remember, the law matters.